Good day, Crime Talk aficionados. I hope you had a wonderful Thanksgiving holiday, and we have a great show for you today. First, closing arguments in the Daniel Penny case. The drunk driver who killed the bride on her wedding day, well, that driver chickens out and doesn't want a trial. Sarah Boone finds out her sentence. Hunter Biden gets a pardon for any crime he committed over the last 10 years, not just his gun and tax cases. A pastor fights an intruder in his church. Better say good morning to this guy or he'll beat you up. We have This Day in Legal History and our dumb criminal of the day. Let's talk about it.
Hi, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below, and you can always hit that little bell for notifications. And remember to check us out on any of your favorite podcasting apps. Before we get to the show, let's pay some bills. Go to crimetalksearch.com. Sign up for that background subscription today. When you do, you'll be able to do a background search on anyone here in the United States. And while you have that subscription, you can do it on as many people as you desire. You're going to find out all kinds of information that maybe these people aren't going to tell you right up front. Like, hey, I have a criminal history. Hey, I may have to register as a sex offender. I may have judgments, liens, or did I fail to mention that I'm still married? Yes, go to crimetalksearch.com. Sign up for that background subscription service today. I'm telling you, information is power. And remember, it's dating malpractice, ladies and gentlemen, if you don't check out that new person coming into your life. So go to crimetalksearch.com. Get that subscription service today. You're going to be happy that you did. All right, let's go ahead and open the record for December 2nd, 2024. Can you believe that? This year, I don't know if it's been a long year, but yet on the same token, it has moved by so quickly. It's just been kind of a beat down kind of year, but I'm feeling optimistic about 2025, ladies and gentlemen. I truly, truly am. So first on the docket, closing statements in the Daniel Penny case. But before Daniel Penny got to the courtroom to hear about, the closing summations by both the prosecution and defense, he arrived to an angry crowd shouting guilty as he arrived in court. Obviously, Mr. Penny is on trial for the death of Jordan Neely. Now, Penny, when he was walking into the court about 10:15 this morning, flanked by his attorneys, as they were getting ready to go in and start the final summations, the closing arguments for the 12 persons on that jury so they can begin their deliberations. Like I said, this group of protesters kept chanting guilty, 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 as the United States Marine Corps veteran, Good Samaritan citizen who stepped in to an angry, troubled man on the subway. That's right, Mr. Penny de-escalated the situation, and now he is being charged for that. So all you Good Samaritans in New York, don't help out. Guess what? You could wind up in a jury trial and fighting for your liberty. Now, for those of you who have not maybe followed this case, Daniel Penny is charged with second-degree manslaughter and criminally negligent homicide in connection of Jordan Neely's death on a subway train back in May of 2023. Now, the incident was filmed on video by bystanders that shows Mr. Penny keeping the troubled, mentally ill homeless man in a chokehold for roughly 6 minutes. Now, prosecutors say that Mr. Penny recklessly killed Mr. Neely by maintaining the hold for longer than Neely could have reasonably been considered a threat, including for 51 seconds after his body went limp. Now, Penny's attorneys have argued that his actions were justified and have claimed that there's reasonable doubt that the chokehold was, in fact, the cause of death for Mr. Neely. Now, the worst district attorney in America, Manhattan District Attorney Alvin Bragg, has not said how stiff a sentence he would seek if the jury convicts Mr. Penny, who has obviously pled not guilty to the charges. Like I said, he faces up to 15 years in prison if he is convicted of the most serious offense. Now, prosecutors say Penny meant to protect people, but recklessly used too much force, overlooking Neely's humanity and making no effort to spare his life. Now, the city's medical examiner ruled that the chokehold killed Mr. Neely. However, a pathologist for the defense disputes that finding and says, no, it's probably a combination of his schizophrenia, the drugs in his system, and just regular poor health. Now, prosecutors have noted that Mr. Penny continued to grip Neely's neck after the train stopped, and anyone who wanted to get out could do so after bystanders urged Penny to let go, and even after Neely had still been on the ground for nearly a minute. Now, multiple witnesses have said that Neely shouted about needing food and something to drink, whipped his jacket to the floor, and said he didn't care if he died or went to prison. Now, there were differing descriptions of his movements and whether they were threatening. Several said that they were, in fact, alarmed by Mr. Neely, and some were thankful that Mr. Penny subdued Mr. Neely. A number of passengers testified that they were scared of Neely and relieved that Penny grabbed hold of him. Now, a man who later stepped in and held Neely's arms down, however, told jurors that he urged Penny to let go, but that Penny kept choking Neely for a little bit more time. Now, prosecutors have painted Penny as an unskilled individual, saying he improperly administered a chokehold for the duration that resulted in Mr. Neely's death. Now, the Marine who trained Mr. Penny to apply a chokehold, combat instructor Joseph Kaballer, conceded that the video filmed by witnesses indicates his old cadet, his old, student, looked to have done so improperly. Well, Kaballer testified that the video appeared to show Penny trying to use a blood choke to restrain Neely, something he said he should have seen him rendered unconscious within seconds. Instead, the hold spanned more than about 6 minutes. Now, during that time, Neely, while within Penny's arms, could have inadvertently turned the clench into an air choke, which takes longer to render a person unconscious and could prove fatal much easier. Now, the hold is not taught by the Marines, he told the jury. Now, the defense contends that Penny held on because Neely tried to break loose at points and that the pressure on the man's neck wasn't consistent enough to kill him. Now, a doctor hired by the defense, Dr. Chundru, who was called to testify on Penny's behalf, blamed Neely's death on a combination of sickle cell crisis and the effects of schizophrenia and synthetic marijuana in his system. Now, the former Miami area medical examiner statement came into stark contrast to the one delivered just days earlier from the doctor who performed the autopsy. Dr. Cynthia Harris had maintained it was neither drugs nor the victim's genetic disorder that took Neely's life, while also ruling out cardiac arrest. Now, during the trial, jurors watched videos recorded by bystanders and by police body cam and saw how Penny explained his actions to officers on the scene and later at an interview at the police station. Penny said, "I just wanted to keep him from getting to people," he told the detectives. He even demonstrated the chokehold and described Neely as a crackhead who was acting like a lunatic. And he said, "I'm not trying to kill the guy." Anyway, Penny did not take the stand in his own defense, because why would he? He's already given his statement. Now, the lawyers noted that the jurors did hear from Mr. Penny in the form of a recorded statement to people minutes and hours after he put Neely in a chokehold. Virtually everything he said then is consistent with credible testimony of his fellow passengers, defense argued. Now, Penny's lawyers have argued and said that Neely lurched toward a woman with a small child and said, "I will kill." Now, Dr. Alexander Bardet, a defense expert who reviewed Neely's medical history, said on the stand he suffered severe schizophrenia for years, including believing dead rapper Tupac Shakur, who ordered him to change the world. Now, Neely also suffered paranoia fears that people want to hurt him, grandiose delusion that people are jealous of him, and reported hearing the devil's voice. Now, despite the nature of Neely's history, the Manhattan prosecutor had sought to bar the doctor's testimony from the trial and attempted to have the evidence of Neely's mental illness and drug abuse withheld from the jury. I wonder why they did that. Anyway, in that testimony, Dr. Bardet said he reviewed thousands of pages of Neely's medical records dating back to 2015. And he'd previously worked for the Rikers Island jail, and witnesses said Neely was screaming about his willingness to return to prison when he threatened subway passengers. He said he had worked on hundreds of cases involving schizophrenia patients and said Neely's case was among the worst of his career. His symptoms I would classify as severe, the doctor noted. He describes paranoia fears that people want to hurt him, grandiose delusions that people are jealous of him, and that Tupac instructed him to change the world. I don't know how that's not reasonable doubt, ladies and gentlemen, and I hope that I am correct. This case never should have been prosecuted. And all these people that come out here and say, oh, Mr. Neely, he's the victim, he's the victim. Where were you when he was out there terrorizing people on the subway, ladies and gentlemen? Where was his family? I see this nonsense in court all the time. And yes, oftentimes my clients have done some very bad things. But when the victim is a bigger piece of garbage than the defendant, don't come in here and make him sound like he is the, reincarnated, Jesus or something like that, when he was just a scumbag, dirtbag victim in the particular case, right? You hear about what a great person he was, oh, this and that and everything else. Well, where were all these people when he had all these problems and they weren't there for him? They all come out of the woodwork. Why? Because they're seeking money. Look at the George Floyd case. Classic example. The guy's couch surfing. He's threatened to kill pregnant women. He is out there, he was using fentanyl. He had fentanyl in his system, for God's sake. Anyway, and then all his family members show up, making him sound like, Saint George. Well, where were all these people? Oh, but they all got their piece of the pie, didn't they, from the settlements? Yes, they did. It's always about the money, ladies and gentlemen. I don't know how many times I keep saying that, but maybe it's starting to process that it's true. Next on the docket, the South Carolina woman accused of driving drunk and slamming into a golf cart, killing a bride on her wedding night, and seriously injuring the groom has pled guilty more than a year and a half after the fatal crash. And guess what? They went to immediate sentencing. And she got 25 years, ladies and gentlemen. So on December 2nd, today, the first day of her trial, Jamie Komorski pled guilty to all charges, including reckless vehicular homicide charge and multiple counts of felony DUI for the April 28th, 2023 tragedy at Folly Beach, South Carolina. The now 27-year-old what's known as a blind plea, meaning that she was not aware of the sentencing prior to the offering the plea of guilty, right? Oftentimes you go in with a plea bargain and you say, Judge, you can limit the sentence to a particular year. Clearly, the prosecutors have said, we're not making any plea bargains, but we have overwhelming evidence. You're going to be found guilty. So more than likely, her attorneys who have said, oh, she's innocent, there's all those two sides of the story. We're beyond plea negotiations. We're here in the day of trial. You're going to lose. We need some acceptance of responsibility. So she pleads guilty. Now, the judge let Ms. Komorski know that she could face decades in prison and upwards of $80,000 as fines, as well as a license suspension and an alcohol interlock system after her sentencing, which began immediately following her plea. Now, those are all the things that the judge has to do, right? Anytime anyone pleads guilty in a court of law, you have to be advised of the nature of the charges to which you're pleading guilty to, the maximum penalties, and you have to be aware of the rights you have and the rights that you give up, right? So most judges will say, do you understand you have a right to enter a plea of not guilty and have a jury trial? In fact, we got a jury out there in the hall, Ms. Komorski. Come on in, let's do this. At a trial, you have a right to enter a plea of not guilty. Make the prosecution prove each and every element of each charge beyond a reasonable doubt before you would be found guilty. That jury decision must be unanimous. At a trial, you have a right to confront and cross-examine all your accusers, to cross-examine those individuals in court through your attorney. Now, obviously, the defense never has to do anything, but you have a right to present a defense. And if you have witnesses that wouldn't come voluntarily, you could then subpoena those witnesses to come to court. And if you went to trial, you'd have a right to testify or not to testify. And if you chose not to testify, the jury would be instructed that they could not use your decision not to testify against you in any way whatsoever. And ultimately, if you went to trial and you lost, you have a right to an appeal. When you plead guilty, except for your right to counsel, you give up all of those rights. So there'll be no trial, there'll be no witnesses, there'll be no prosecution to prove their case beyond a reasonable doubt. that is it. There's no buyer's remorse. You don't get to come back and do it again. So, like I said, she got 25 years for all the counts. Many of the counts will run concurrent, but the ultimate sentence is 25 years. Now, if you're not familiar with this case or you need a refresher on it, investigators said that Ms. Komorski was driving 65 in a 25-mile-per-hour zone with a blood alcohol level more than 3 times the legal limit when she plowed into the newlyweds moments after their wedding reception. Now, the bride, Samantha Miller, she was 34, was killed in the crash. 3 others who were in the golf cart, including the groom, Eric Hutchinson, were severely injured. Now, Ms. Komorski was released on bond in March, 7 months after the judge initially denied bond and informed the parties that Ms. Komorski would be released if her case wasn't heard by March of 2024. Now, Ms. Komorski was released on a $150,000 surety bond. She was ordered to wear a GPS and a SCRAM unit, which is a secure, continuous remote alcohol monitoring device. Now, the SCRAM bracelet can detect alcohol in a person's system through sweat. Now, I have heard of people putting like a piece of bologna in between the SCRAM unit if there's a little bit of thing in there, and guess what? So there you go. Anyway, earlier this year, Hutchinson and the other survivors of the crash filed a wrongful death lawsuit that accused Ms. Komorski of setting off a booze-filled day of bar hopping that culminated with her BAC being a .261 when it was tested after the crash. Now, a judge approved a partial settlement in that lawsuit, awarding $1 million from several businesses in that case, also known as a dram shop in many jurisdictions. If you overserve somebody at a bar, the bar can be held accountable if they can prove, if the plaintiffs can prove, that the person was intoxicated at the time of being overserved, and the bartender knew of that, and they kept continuing to serve. Just the law. Anyway, Ms. Komorski, 25 years in prison, which is kind of the going rate for a dead body. Here in Colorado, if you kill somebody on a vehicular manslaughter, or I'm sorry, a vehicular homicide case being drunk, or some sort of extreme indifference, it's 12 years is the maximum penalty unless you are aggravated. So 25 years, a little high, but hey, it's South Carolina. They usually don't play down there. And this is a pretty aggravated case in light of all the other injured parties as well. Next on the docket, Sarah Boone. That's right. She had her sentencing today. And oh, what a painful sentencing this was. Okay. Now, Sarah Boone was convicted of murdering her boyfriend by suffocating him in the suitcase. And like I said, she was sentenced today in Orange County, Florida. Just a little background before we get to my discussion of the sentencing, which was painful. But back on October 25th, a jury took about an hour and a half deliberating in the murder trial of Sarah Boone, also referred to as the suitcase murder. Now, Boone was found guilty of leaving her boyfriend Desai zipped up inside a suitcase for about 11 hours inside of their Winter Park home. Now, the medical examiner testified that Jorge Torres died from suffocation. His family declined to comment after the verdict, but they were heard today. Anyway, Miss Boone's defense attorney described Sarah Boone as shocked and disappointed. Just shock. She's shocked. She felt like, she had a defense. So this whole jury verdict came as a big shock to her. I don't know why. She didn't have a legitimate defense. Anyway, during the trial, Boone took the stand in her own defense, describing how her 103-pound boyfriend got into the suitcase in their little game of hide and seek. She said, "I zipped him up, thought it was funny. We're joking about how he was small enough to fit inside the suitcase. Just joshing around." Anyway, Boone told the jury how Torres threatened her, and the defense introduced photos of how Torres had injured her during their 3.5-year relationship. Psychologists took the stand to back up the battered spouse syndrome defense, which failed miserably, probably because the state's experts said Boone's behavior was not indicative of a battered spouse syndrome. In the end, the prosecution said the guilty verdict brought some closure for the Torres family. And after 4.5 years, the number of delays, I think they were finally happy to see the case finally go to trial and put this one in the book. Now, Boone requested a new trial, claiming she was wrongfully denied a court-appointed attorney. She also said the emotional outburst in the court by the victim's family should have caused a mistrial. Denied. Denied, denied, denied. All right? So obviously understand, at a sentencing, the victim's family gets to talk and say what a great guy the boyfriend was. I get it. I'm okay with that. They've waited this time. They get to speak their piece. But the defense attorney for Ms. Boone, oh my God, sit down, shut up, and say, Your Honor, there will be an appeal, and therefore I have instructed Ms. Boone not to say anything further. So bring it on. But no, not only did this attorney put Ms. Boone on to make a sentencing statement today and basically say, well, you didn't know the whole story, and then on top of that, basically gets up and tries to relitigate the case to the judge. We provided you video of the entire sentencing. If you'd like to watch it, you can. It's about 2 hours long. Statements by everybody, hour and 55 minutes. Statement by the judge, less than 5 minutes. And what did he give Miss Sarah Boone? Life, 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 although she was given 4 years, 9 months, and 8 days credit. I hope this is the last we hear of Miss Boone. Somehow I don't think it will be. She will be claiming that she's been wronged and harmed for the rest of her days in custody. It took 4.5 years to get to this point. She is borderline delusional if she thought that she had a battered spouse syndrome, and that's probably why the 8 previous attorneys said, you're going to lose, and to take the deal. But clearly, Miss Boone knows better. She is smarter than everybody else. Next on the docket, Hunter Biden gets a pardon. Now, listen, I don't know how many people have been following this, but if anybody thought Hunter Biden was not going to get pardoned, those people are delusional. Now, of course, I've seen a montage of everybody that on the news, the talking heads, that would say Hunter Biden is not going to get a pardon from his father because his father is an honorable man and there is respect for the rule of law, because that was kind of the whole argument as it relates to the rule of law in the election, correct? So no, we're not going to do it. Biden said himself and through his spokesperson, he would not pardon his son. He's going to respect the process. Obviously, that didn't happen. As yesterday, President Biden pardoned his son, not only for the case in Delaware where he was a prohibited person, and not for the tax case where he faced, I think, 9 or 12 counts of tax evasion, where on the morning of trial, he pled guilty. And at that point, I knew he was going to get a pardon. Because he's like, guess what? I'm pleading guilty straight up. Don't need any protection, kind of like our South Carolina drunk driver. I'm just going to go in and do this. And that's what took place. Now, let's be clear. The president has the absolute power to pardon. And I thought it would be worth noting. So I pulled out my pocket constitution just so I got this correct. I wasn't giving you some bum information. Article 2, Section 2. The president shall be commander-in-chief of the Army and Navy of the United States and of the militia of the several states when called into actual service of the United States. He may require the opinion in writing of the principal officer in each of the executive departments upon any subject relating to the duties of the respective offices, and he shall have power to grant reprieves and pardons for offenses against the United States, except cases of impeachment. There you go. Article 2, Section 2. Absolute power. He doesn't have to explain it. Presidents have done this throughout their entire time. But let me tell you, normally what the general criteria is for a pardon is that the person has basically been found guilty or pled guilty, gets punished, gets through the punishment, and then thereafter usually lives the life of like a Mother Teresa, doing nothing but good, helping people, and never getting in trouble ever again. And I get that. That's the way things take place. This case, obviously, Hunter Biden hadn't been sentenced yet in either of his cases. And the thing that's a little bit shocking here is that he was granted a reprieve from January of 2014 through December 2nd of 2024. Never such, I don't think it's ever been done, somebody will correct me if I'm wrong, such a broad sweep of the pardon where it's over a 10-year period. Now, obviously, what the president was worried about is that now that there's a new sheriff in town, that Hunter Biden was more than likely going to be investigated and possibly charged as it relates to Foreign Corrupt Practices Act, as it relates to his involvement with Chinese hedge funds, as well as Burisma, the oil company in Ukraine, where he was getting paid, I think, some $86,000 a month. Well, he had no experience in the oil and gas industry. It happens all the time, right? No, the reality of it was selling public influence. There's emails to back all that up on the laptop computer of Hunter Biden. Anyway, the president did what he did, and let's face it, if that was my kid, I'd probably pardon him too. But usually when these pardons are given out, the presidents do it on his last day in office. I guess he just didn't want Biden to have to go to sentencing. Anyway, of course, a lot of people are slamming Hunter Biden for lying, saying Joe Biden has lied from the start to finish about his family's corrupt influence peddling activities. I think that was James Comer who said that. And the man that was leading the Biden investigation in the House of Representatives. Now, the charges Hunter Biden faced were just the tip of the iceberg in a blatant corruption that President Biden and the Biden crime family have lied about to the American people. This pardon could ultimately stop those investigations against President Biden, who will more than likely never be prosecuted because he's just a forgetful old man, i.e. not competent. Do with it what you want. Anyway, but the question will now become, does Hunter Biden's uncle, Joe Biden's brother, who was doing the same thing, making $31 million, I think, from Chinese individuals or companies that was distributed amongst the Biden family through, I think it was 31 different LLCs, whether he will get a pardon as well, or whether he will not be charged and left to hang out there on his own. Now, the interesting thing is that if the congressman wanted to go after the rest of the Biden family, he would have to appear and testify truthfully because he has no Fifth Amendment right against self-incrimination anymore. I'm sure there'd be lots of I don't recall, but the reality of it is he could be forced to answer those questions. And if he didn't, he could be held in contempt of Congress and all those other types of things, which just really start things all over again for him. Now, Hunter Biden said that he will not take advantage of this clemency, and he is going to do good from here on out. He's been sober for the last 5 years, and he's going to do good. Anyway, we'll see. Interesting thing is lots of Democrats are a little upset by this. In fact, our own Governor Polis here in the state of Colorado said it shows that there's two tiers of justice, those for the politically connected and those who are not. Can't necessarily disagree with the governor on that one. And I'm telling you, these things are hard to come by, ladies and gentlemen. Over my years, we submitted an application for a client, did something very stupid when they were young, went on to be very successful, never got in any trouble again. And the governor said, no, come back in a few more years. So they're very difficult to come by. And usually there's some sort of package that is submitted. Be curious to see if that, in fact, comes about in the Hunter Biden case. Next on the docket, the JonBenét case. That's right. Police in Colorado say they believe they are close to solving the murder of JonBenét Ramsey, the 6-year-old beauty queen whose death back in December of 1996 shocked the world. Now, a new documentary examines the case of the little girl who was found strangled in her basement of the family's Boulder, Colorado home, and the killer of the young Miss Colorado left her on a heap of clothes with an 8-inch fracture to her skull and a fragmented paintbrush stuck into her neck by a garrote. Now, a bombshell admission by a police source has also given investigators fresh hope in finally solving the 28-year-old mystery. We effed up the case from the start, and now with new blood, we can finally fix it. That's from an unidentified former police source. Now, the stunning statement comes as Boulder's newly appointed police chief, Stephen Redfern, doubles down on efforts to crack the case. Now, Redfern, who assumed the role back in early 2024, has made solving the murder a top priority. He wants it solved and off the books, according to people with the department. He's assigned officers and resources to solve the murder, which has been a black mark on the Boulder Police Department. Now, JonBenét's murder has haunted investigators and gripped the public imagination for years. Now, while initial suspicion centered on her family, Father John, Mother Patsy, and Brother Burke, DNA evidence excluded all three of them as suspects in 1997, and they were formally exonerated in 2008. Now, despite a multi-agency task force established in 2023, progress has still been very slow and obviously no success. One investigator admitted that the task force has only met in person once, but emphasized that these members remain in regular contact. Now, last week, Chief Redfern reaffirmed the department's commitment to solving the case in his annual departmental update. Anyway, the killing of JonBenét has been an unspeakable crime, and the tragedy has never left our hearts, the new chief said. We are committed to following up on every lead and continuing to work with DNA experts and law enforcement partners around the country until this tragic case is solved. The department's credibility still remains under fire all these years for the handling of the JonBenét Ramsey case. Anyway, authorities have indeed sent several items for renewed DNA testing, but significant breakthroughs have so far remained elusive, and the DNA evidence in the case has long proved problematic, with Boulder's own police being heavily criticized for the mishandling of the investigation. And back in 2015, former Boulder Police Chief Mark Beckner admitted crime scene evidence may have been mishandled on a Reddit forum that he was commenting on. He said, quote, "The crime scene was not handled properly, and this later affected the investigation," he said. Someone with the Boulder Police Department defended their efforts, pushing back against those claims of negligence. The assertion that there is viable evidence and leads that we're not pursuing to include DNA testing is completely false, Mr. Chief Redfern stated. There you go, ladies and gentlemen. Apparently, all you need to do to get anything going on any sort of a true crime case is have a Netflix series. Look at the Menendez brothers. Everyone forgot about them. 30-some years in jail, prison, and they're still, nobody cared. You get something put on Netflix, next thing you know, what can I say? You are the cause celeb of today. Now, don't get me wrong, this case, I mean, it's just not that far. It's like 12 miles away. And every time we go to Boulder and we go to Chautauqua Park, where people go hiking and you can rent homes there, not far from the campus, guess what? That's right. Drive by the old Ramsey house and point it out. Let everybody know. Usually people that aren't here, that's the Ramsey house. That's where JonBenét was killed. Do it all the time. Anyway, next on the docket, even a minister is not safe. A pastor, a California pastor trained in mixed martial arts, fought off an axe-toting burglar who broke into his church on Thanksgiving. Now, the burglar used an axe to smash open a window at the First Family Church Anatok in the early hours when he was confronted by Pastor Nick Nieves, who had gone to check on the church after hearing a security alarm go off. Now, the would-be thief, who had not been identified, tried to fight the preacher. Now, the preacher said he shouted at him to stop, and the police were on their way. Anyway, the guy ran away, and the pastor grabbed a hold of him, which ended up in a wrestling match in the parking lot. Apparently, the pair grappled for about 15 minutes as Nieves utilized some of his training in various martial arts. Apparently, the pastor likes to stay fit. He studied some jiu-jitsu and some kickboxing and a little bit of mixed martial arts as well. Anyway, the pastor was able to pin this guy to the ground, and he got up and tried to get away several times, but the pastor used his jiu-jitsu training, and basically the pastor said he was just trying to wear this guy out because he knew that he was going to outlast him. Good thing he didn't put him in a chokehold, otherwise he'd be charged. Anyway, the pastor said he wished the man had simply walked through the church, come through the front doors, and they would have given him whatever he was more than likely asking for. The church already provides groceries for some 130 local families in the area. Now, the pastor says it's ironic. If he had come a couple of days earlier, he would have been blessed, received some food, and been cared for. But he decided instead to smash windows and desecrate property and do something that's going to actually hurt the ministries. Pastors, man of the cloth. Where does it end, ladies and gentlemen? I know people have always broken into churches. Didn't your mother teach you, if it's not yours, you don't take it. Keep your hands to yourself, right? Just simple common sense. And you go to a church, they'll give you, I am not aware of any circumstance where somebody said, I want to go to a church. Can you please help me? I've never seen a circumstance where the person asking for help was not given some aid or assistance in some way. But when you go in with an axe trying to harm the pastor, where's Daniel Penny when you need him? Anyway, you may want to say good morning to this guy. Otherwise, he will punch you. That's right. This man attacked a woman for not saying good morning. Now, this is a ridiculous excuse a Boston man gave after viciously attacking a woman gardening in her own yard. Now, this man has been convicted of assault after he attacked this woman because she didn't say good morning to him. Ian Atkinson savagely beat a 59-year-old woman as she was watering her plants in her home, her own yard in Boston. Now, the ordeal took place back on July 13th of last year while Mr. Atkins was wearing an ankle monitor for a previous offense. Now, prosecutors told the court that the attacker was sparked by Mr. Atkinson, who told the victim, when people say good morning to you, you should say, hi, you crazy biatch. Now, his lawyer claimed he was acting in self-defense and accused the woman of spraying him with a garden hose and then biting him. However, that story fell apart in court after the victim was able to produce a cell phone recording of the attack. Now, the clips show Mr. Atkinson getting out of his black Mercedes and sort of stomping over to the woman before unleashing a hail of blows to the 50-some-odd-year woman. Anyway, the first punch landed with a sickening blow, silencing the woman who had been singing just moments before. Additional surveillance footage showed another angle of the attack, as well as Atkinson attempting to mow down the victim in his car. The woman was left with a broken nose, severe bruising to her head and face, and a burst blood vessel in her left eye. Now, police arrived at her home at around 9 a.m. and found her bleeding profusely. She was then taken to a local hospital for treatment. Now, Atkinson, who didn't know this woman beforehand, was arrested a few days later after she was able to note down his license plate. Police were then able to track him to his residence. That's why, because he was wearing a GPS. That's why. Wearing an ankle monitor when you're on pretrial release to a crime scene, not smart. That's almost as dumb as bringing your phone. Anyway, Mr. Atkinson exercised his right to go to trial, but waived his right to a jury trial and was found guilty by the judge of battery and assault with a deadly weapon. He was sentenced to 2 years in jail and another 2 years on probation. He's previously been convicted of drugs and assault. This guy only got 2 years. Where I come from, you assault somebody in their mid-50s, I think you're getting close to at-risk adult. That'd be felony behavior. This is clearly misdemeanor behavior. Unbelievable. What are we doing? Boston, Massachusetts, what are we doing? I don't know. Next on the docket, this day in legal history. 1895 on December 2nd, 1895, in Sparf v. United States, the court ruled that the federal judges are not obligated to inform juries about their right to nullify laws. That's right. Judges, you can't talk about jury nullification. And so this law, or that ruling, precedent, 1895. And then In 1866, on December 2nd, 1866, the United States Supreme Court decided that the government could not try civilians in military tribunals where civilian courts were open, emphasizing the habeas corpus rights to have a trial. And then on December 2nd, 1954, Dr. Sam Shepard, a physician accused of killing his wife, was taken into custody. His conviction was later overturned by a United States Supreme Court due to media influence on the trial, obviously leading to the discussions of one's right to a fair trial with extensive media coverage. There you go, ladies and gentlemen. There you go, ladies and gentlemen, your day in legal history. And finally, our dumb criminal of the day. A Florida man was arrested for two separate thefts that occurred within 15 minutes of each other. Please meet our dumb criminal of the day, Andrew Sylvester. Now, he is accused of 2 counts of felony retail theft, and in each instant, the defendant allegedly stole several $100s worth of products from the Publix supermarket. Now, apparently, Mr. Sylvester tried to steal not 1, but 2 carts full of groceries from Publix. The stunt landed him in the county jail where he is arrested. Now, obviously, he has been arrested, and the sheriff noted that this little stunt landed him in jail, and he says that it is their pleasure to arrest criminals. Anyway, as the story goes, on November 12th, deputies were called to the Publix in Lakeland, Florida, which is about 30 miles east of Tampa. Now, the Publix supermarket chain is employee-owned and operated throughout the majority of the southeast United States, but they're headquartered there in Lakeland, Florida. And when the deputies arrived, they located Andrew outside of the store with a shopping cart full of groceries that he had not paid for. Anyway, the value of the items in the shopping cart number 1 was $243.92. And then a store employee allegedly said the defendant had pulled off a similar stunt less than 15 minutes earlier before he tried to do shopping cart number 2. Anyway, the other cart from the store was valued at $206.10. In sum, Mr. Sylvester is alleged to have attempted and steal a combined food items, not his, that he did not pay for, of $450. Now, under Florida law, retail theft is highly criminalized at the basic level and is considered a felony in the 3rd degree, punishable by a prison term of up to 5 years. Now, most states, that would be a simple misdemeanor, but not in Florida. I think that's why we have so many dumb criminals coming from Florida, and they have great open records laws, ladies and gentlemen. Great open records law. There's no privacy for criminals. Anyway, that's all we have for today. Hope you enjoyed the show. Thanks for watching. We'll see you next time. And remember, the Constitution matters.